Good afternoon, friends. Let us solve one more question relating to advocate note code examination. I am firstly reading out the question, then I will answer that question. Question is, your client shouted objectionable slogans before a divisional bench of the High Court, which was hearing his writ petition and was dictating an order averse to your client's interest. Despite various warnings being issued to their client, he continued to shout and berate the judges of the court. Thus, on the order of the High Court, he was taken into custody on the same day. You are requested to move the Supreme Court against the custody order. What is the appropriate proceeding that you would file in the Supreme Court and give reasons to support the remedy that you would choose? This is the long question. So, friend, in this scenario, our client's conduct resulted in High Court exercising its contempt jurisdiction under the Contempt of Court Act 1971, leading to custody order. To challenge this order in the Honorable Supreme Court, the appropriate proceeding would be to file a SLP, specially petition under Article 136 of the Constitution of India. Now coming to reason for filing SLP. Firstly, nature of the order. The custody order is effectively a punitive order under the contempt power of the High Court. Honorable Supreme Court has the power to entertain an SLP against such orders to ensure procedural fairness and adherence to legal principles. So we have rightly gone to Supreme Court for SLP. Secondly, extraordinary jurisdiction. Article 136 provides the Supreme Court with wide discretionary powers to hear appeals against orders, decrees, judgments from any court or tribunal in India, including those passed in contempt proceedings. Third reason being lack of adequate alternative remedy. Contempt orders, particularly those involving custody or imprisonment, have immediate consequences, and remedies like review or appeal with the same High Court may not provide timely relief or effective relief. This is the third reason. Violation of principles of natural justice, if they are applicable, that can also be raised. If the custody order was passed without giving your client an adequate opportunity to explain his behavior or without following proper contempt procedure, the Supreme Court can examine such violation. There is, friends, scope for mitigation. Honorable Supreme Court may be persuaded to examine whether the punishment was disproportionate to the act or if the client's conduct could be addressed with a lesser penalty, such as an apology or fine. So these are the circumstances which cause reason us to approach the Supreme Court. Now, friends, what steps we will take? Firstly, we will have to prepare and file the SLP. So, draft the SLP by clearly articulating the factual background, procedural irregularity or disproportionate nature of the custody order, grounds for invoking the Supreme Court jurisdiction under Article 136, and attach relevant documents, including the High Court order and transcripts if available. And in this SLP, ask for interim relief. Along with the SLP, file an application seeking interim relief to suspend the custody order pending final disposal of the petition. Then we should also stress on grounds of challenge, highlighting mitigating factors such as client's emotional state, lack of intent to undermine the dignity of the court, or immediate willingness to apologize. These can be the best ground in this particular case. Also, argue procedural lapses such as absence of formal contempt notice or hearing. So, friends, I have explained a lot. Still, I am giving one or two case laws which are giving relief to us. First case is of Dr. L.P. Misra versus State of UP, 1998. Friends, in this case, Honorable Supreme Court held that contempt proceedings should strictly adhere to the principles of natural justice, and orders passed in haste can be challenged. Our order 2 was passed in haste. So this case law is giving somewhat little relief to us. Second case is Rama Dayal Markada versus State of Madhya Pradesh. This is of 1978. The Honorable Court observed that sentences in contempt cases should not be disproportionate and must be imposed only when absolutely necessary. So, friends, this remedy of SLP ensures a swift and appropriate challenge to the High Court's custody order, safeguarding the client's rights while respecting the dignity of the judiciary. So, friend, in this adverse circumstances, you still have you can say, if you have knowledge how to handle the adverse situation, you can easily pass through. So this is the best method which I have explained in this video. If it happens in future also with you, you can take this help. Otherwise, for academic purpose, it is also good. I am sure that there will be a short question like this of 2 marks. If it is of more than 2 marks, then it is your luck. Be prepared. 2 months left. Go on studying, hard work. You will surely get a success.